Good afternoon, Judge Kganyago.
Good afternoon, DCG.
Are you comfortable?
Yes, I'm comfortable.
All right. Can you tell us a little bit about yourself? Who is Judge Kganyago?
Judge Kganyago is the judge of the Limpopo division. I was appointed during January 2017, and currently I'm having 5 years being appointed as a judge. I'm based in Limpopo, in Polokwane High Court in Limpopo.
Please pull the mic closer to you. Thank you. Carry on.
As I've already stated, currently I'm based in Polokwane. I am married. I'm having 2 children. Who currently, one is at the university. He wants to follow into that. She's also doing law, and the other one is doing aviation. And my wife is an educator. I'm also staying in Polokwane.
What did you do before you became a judge? You were an attorney, right?
Correct, DCG.
For how long?
I've practiced
Long time.
for 23 years.
You did not tell us about your academic qualifications. You did not just become an attorney.
I did BProc at the University of the North, now is University of Limpopo. Thereafter, I did some articles. After obtaining some articles, I started practicing. Whilst practicing, I enrolled for an LLB, which I completed while working. I also did a diploma in insolvency law and practice, and also a certificate in pension funds law, deceased estate. I also enrolled as a liquidator and trustee in insolvent estate. And I was also a member of the company's tribunal. I was a part-time commissioner at the CCMA and also various bargaining councils. I was admitted as an attorney on the 30th of November, 1993.
Yes. The Limpopo division has 2 seats, right?
3.
Or 3? I only know of, which is the third one? I know of Polokwane and Thohoyandou.
Le Palale has been declared a fully fledged circuit court of Polokwane sometimes back, but up to now it is not yet functional.
Oh, I see. Have you had occasion to sit in the Thohoyandou seat?
Correct. That's why I even started my acting stint.
All right. You want to become judge president of that division?
Correct.
What observations have you made about any improvements that may be necessary? Well, I know that there are challenges, but I need you to tell us what those challenges are and how you plan to address them.
Limpopo is a unique province. It's dominated by the Pedis, the Tsongas, the Vendas, the Whites, the Indians, the Coloureds, the Ndebeles. Currently, in both divisions of Thohoyandou and Polokwane, we are having 9 judges. Out of the 9 judges, 6 are Pedis, 2 Whites, 1 Venda. And out of the 9 judges, 7 are male, 2 are female, 1 black, and 1 white. It is clear that the challenge is the issue of transformation, of which the issue of gender representative is lacking. The demographics of the province has not well been represented, as it seems as if the Pedis are dominating. And for the public to have confidence in the courts, it must also be reflective of the demographic of the province, and not one tribe or one race to dominate the other. Otherwise, it will be seen as a petty court, and it will not reflect well. That can be addressed by increasing the pool of acting judges, which is reflective of the demographics of the province, and also gender representative. Counsel do appear before the courts on a daily basis. We see how they argue their matters, how they draft their papers. We do appeal on a routine basis from the lower courts. We see how they write their judgment or handle their matters, and how they apply the law on those judgments. So based on how they apply the law on those judgments, how the counsel argue their matter, and how they draft their papers, it will be easy to see whether they are ready to be called for acting stint. After all, nobody was born with experience. It is for us to mentor and train them. And in that way, we'll be addressing the issue of transformation. The other issue is the issue of the Lephalale Circuit Court, which has been proclaimed long time ago, and currently it is not yet functional. I'm quite aware of the challenges of manpower in relation to judges who should go to Lephalale. However, that is not confined to Limpopo alone. It is a national problem where many courts are struggling with the issue of manpower. My philosophy on that is that justice, access to justice must be seen to be done by taking justice nearer to the people. From Lephalale to Polokwane is about 250 kilometers a single trip. From Tabazimbi to Polokwane is about 300 kilometers a single trip. From Tabazimbi to Lephalale is about 160 kilometers a single trip. So for an ordinary member of the public to travel a distance of 300 kilometers with the less resources which he's saving to arrive in Polokwane, and the matter is to be postponed, it is really inconveniencing. So my take on that, with the limited resources which we are having, is to have a meeting with the head of the administration of the Lephalale Court. If maybe per month he can give us 1 or 2 weeks, in which, for a start, I had an opportunity to sit in the criminal court, in the motion court, in the civil trial. I've seen that there are many matters which come from that jurisdiction. For a start, those matters can be clubbed together, both motion and civil trial, and make a judge available to go and sit in Lephalale for that week and do those matters. In that way, I will be building that Lephalale Court be a fully fledged running court until we find a permanent judge who will be sitting there permanently, dispensing justice and making access to justice nearer to the people. Currently, there are also circuit courts in the criminal court, which usually was sitting in Lephalale, sitting in Phalaborwa, and also Skhosese. Phalaborwa is also about 240 something, a single trip from Polokwane to Phalaborwa. As I was sitting in the criminal court, I've seen that there are most matters which come from those jurisdictions which will be spread throughout the term. So my philosophy will be to have a meeting with the NPA, to club those matters together, and at least we have a week, 2 or 3, for a judge to go to Phalaborwa to do those circuit matters. In that, we will be able to achieve the same stats which we will be able to achieve in Polokwane, and also taking access to the people. I can give an example. Around 2018, I had a matter which I was doing in Polokwane. It emanates from Mankweng area. The state key witness was coming from Stalop Township, and he was ill-disposed. His doctors advised him not to travel long distance. We had to go to Tabaleshoba periodical court, which is a periodical court of Mokopane, to take the evidence of that witness. Even though that matter was not emanating from that area, to our surprise, when we arrived at court on that particular day, that periodical court was full to the capacity. I don't know how they knew that the court was going to sit, just for the members of the public to come and see how the High Court functioned. It shows how the ordinary citizens of ones are longing to see justice being nearer to them. When in the criminal court, in some instances, we start very late because the witness would have arrived late. And Limpopo, remember, is a rural area where the witness to travel to Polokwane, they depend on the IO who must collect them. And when you question the IO as to why they were late, the IO will tell you that he or she, they have woke up around 4 a.m. collecting the witnesses from all the remote areas, but still they will arrive late. And if those witnesses have not yet testified, they will have to travel back to those remote areas. And remember, the court knocks off at 4:15, it starts at 10 o'clock. So it will be like that for the whole week. By the end of the week, the IO will be finished. And in that way, I don't think that we're doing justice to the IOs. We expect them to be at court on time and to be in attendance for the whole time, and also to travel back, of which are also putting their lives at risk. So access to justice, it means taking the courts nearer to the people. The other issue that I have identified is the issue of the files which are lost time and again at the court, wherein we operate on duplicate files. In some instances, you find that documents are not in the court file. I had an opportunity to tour the general officer of the High Court of Polokwane, and also the archives where it is in the basement. What I found there, I found that the biggest problem was the issue of the space for filing of files. They told me that the files which has been stored here is the files of Polokwane, Thohoyandou, and some of the files are coming from Gauteng Division. The cabinet which I used to store the files is full in both the general office and the archives, which is in the basement. And that resulted in now they are storing the files on the floor. And those files now are becoming mixed up, which it is no longer easy for them to locate the file. And the shortest route is for them to make duplicate files, which is now resulting in duplicate files being made. The other problem is that the basement is in the parking lot, and the parking lot, in some instances, it overflows with water. That water overflows into the archives where the files are being stored. And there are also some files which now you can see that they were wet. And I'm talking of living files which are still, the matters are not finalized. If you look at those containers which are in the basement, they are also rusty to show that they have been affected by water. I can give you the stats for the files which is from 2015. For 2015, 2,653 files were issued. 2016, 6,121 files were issued. 2017, 8,480 files were issued. 2018, 7,706 files were issued. 2019, 8,874 files were issued. 2020, 7,960 files were issued. And 2021, 9,451 files were issued. As of the 3rd October 2022, 10,905 were issued. 2016 up to 2018 files have been moved to the archives, which is in the parking lot, which is having a problem of water sometimes being overflowing. And 2019 to 2022 files are still in the general office. Because of lack of space, the 2015 files have been moved into one of the holding cells of the awaiting trial list. And you can see that this court is growing at the fastest pace, meaning that every year we'll be shifting files to the holding cells. And if the holding cells become full, the question is, where are we going to put the high risk awaiting trial list? It is not conducive. At some stage, we'll be forced to sit them in the gallery. The other issue is, which I've identified for the first time when I was allocated the civil trial role for it was in the second term of 2022. I found that in the civil trial role, there was no consistency of allocating dates. When I started at the beginning of the term, I was told that they were already at September 2023 in the allocation of dates. But to my surprise, on the second term, there were files which emanate from the first term, which they were postponed in the first term or removed in the first term, but have already made way to be allocated the dates in 2020, in the second term of 2022, with backdated notice of set down without application for trial date. The one which I found that it was a masterpiece. The matter was heard on merits on issue of liability. It was dismissed. The appeal was heard on the 4th of March 2022, and it was successful. And quantum was postponed sine die. However, that matter made way to find a date of set down for the second term, with a notice of set down backdated to October 2021, with a date of stamp of the register also backdated to October 2021. And these issues, I brought them to the attention of our DJP, who also told me that at some stage, one day he was listening to Radio 702, and he heard on the radio that in Polokwane, for one to get an expedient date, he had to pay something, and you'll get an expedient date. For a week, a judge is being allocated, who sit in the civil trial, is being allocated 60 to 65 files. But when I looked at those files, they were now escalating to more than 70. And when I checked, most of them, they were those who had been improperly set down. Then I have to intervene and ask to call the register who are responsible for allocation of dates. Initially, they told me that there were some practitioners who told them that I have made an order that the matters must be enrolled for that week, which was not true. I told them to go and identify those files so that I can be able to deal with those matters in court. But the registrar came back and said that, no, it was one of the judge secretary who brought the files and then said that they must be enrolled for that week. I had to call the chief register to place in some control measures so that it cannot be free for all. And I can tell you that the following week, the file dropped from 70 to 48. And for the remainder of the term, they were now ranging from 48 to 57. It was only in the last term where it was 61, which is very worrying, because they say that they were already at September 2023, but after discovering all these issues, now the file drops, meaning that that role basically is not basically at September 2023. My take to resolve this is to the introduction of electronic filing and electronic record-keeping system. And that will resolve the issue of the space, the issue of the manpower which the general office is having, the issue of improper allocation of dates, as the system itself is updating itself, or if whenever you file a document. And I don't see any problem in starting with a system of electronic filing and electronic record keeping, because the chief register for now, he has already underwent training for case line and is ready to implement that. And also there is the issue of Thohoyandou, wherein Thohoyandou was a court which was formed during when it was still the Republic of Venda. It is having 3 courts. And out of that, when the new dispensation come in, the jurisdiction of that court has been increased, but the courts have not been increased, and it is also growing, which is also a challenge, which will need me, the OCJ, and the Department of Public Works to have a meeting and have a priority and how that will be resolved. Because 3 judges right now are not coping. So far, that is the challenges which I have identified.
Wow, that's quite a list. You mentioned transformation as one of your concerns.
Correct.
Yeah, I'm going to ask you a question that you're probably not the person to ask, but you are from there and you should know. You spoke of a DJP, and I just remembered that there is a DJP there.
Correct.
Where is she? Do you have any idea why she has not applied?
Yes.
Can you tell us?
When the position of the DJP was advertised, I also had an interest in applying. But we were having a close working relationship with her. She indicated that she's having an interest to apply. Because I'm having confidence in her that she was going to make it, I decided to take a back seat. She applied, and indeed, she was appointed the DJP. Unfortunately, she applied very late. So now when this position of Judge President was advertised, I went to her to tell her that this time I want you to do the thing correctly. You must not apply at the 11th hour. You must apply on time so that if there's anything which went wrong, you must be able to rectify it. She told me that she's not going to apply, but she's not, at that stage, she's not prepared to tell me the reasons why she's not going to apply. And she encouraged me to apply, that she's having confidence in me and I must apply with her blessing.
All right. Some of the interested parties who have submitted reviews on your competency and abilities as a judge have not said complimentary things about you. But the refrain is that you have not had an opportunity to act as a DJP. They do list other things that you've not demonstrated, leadership qualities, the way you flout the case flow management system, the way you handle the court role actually ends up clogging the role. Those are just some. There are a few other things. You know what they are. How would you respond to these criticisms?
I'll start with the one of not having acted. It was not as a result of my fault. We don't apply to act. It is up to the JP to decide who acts. Had I been approached, I was available and willing to act. On the issue of the role, which I've seen that they said I've collapsed the role for the second term, it was as a result of the issues that I have discovered that they were not done in the proper way. Like the others, I have already mentioned them. I found that in the civil trial role, as I've already mentioned, I was told that the role was already at September 2023. But there were matters, it was clocked by the matters which were on the second term of 2022. And that when they apply for those dates, they were not having any application for trial date. But surprisingly, those matters were set down which was backdated to 2021, while they were already on the trial roll for 2022. The other issues was the issue of filing of fraudulent expert affidavits. I've already written 4 judgments on that issue. And I have even at some stage requested the parties to call the doctor to come and verify. The doctor came and verified that the affidavits were not his, and even went to an extent to distance himself to the reports, the actual expert reports, that those expert reports were not his. And this was not an isolated incident. It was it was prevalent. If you look at the 4 judgments that I've written, it shows how prevalent it was. In some instances, they were commissioning copy of the expert affidavits with different dates. The expert will sign a copy on a different date. The commissioner will commission it on a different date. Those were not proper affidavits in which you will grant a default judgment, because that clock is mostly rough matters, which rough is not present. And had I granted orders in those matters, I would have granted orders which are void. And in those instances, that is the matters in which I've refused to grant the orders. Some of them I've written the judgment which I've referred. And on the issue that I'm lacking temperament, I'm going to give an example. In 2018, I was in Thohoyandou. There was one counsel who was very disrespectful, talking the way he wants, to an extent that one of the counsel recorded him, the way he was addressing me in court, and the way I was handling him. And that recording went viral. And I remember some of the senior judges phoned me to compliment me how I have handled that matter. Some of them even went to an extent that had it been them, they would have cut him short. In 2022, the role which they say I have collapsed. As I was discovering all these issues which I'm talking about, one of the counsel told me in open court that it seems as if I have chosen the wrong career. I should have joined General Libya of the Hawks. But I took that as a compliment, and as the whole gallery and the court were laughing, I took that as a compliment. Because had I entered the fray, I was going to turn the court into a circus.
All right. Do you have any reported judgments?
I'm having 4 reported judgments, and the other one which was not reported, the fifth one which was not reported, it was quoted by Ditoy in the commentary on Criminal Procedure Act on Section 3004 dealing with the reviews.
Let's just give it a second. All right. Commissioner Bernard, we did not lose you.
I am here, DCJ.
Thank you.
Can I continue?
No, I was just waiting for the
Oh.
IT
Okay.
gentleman to finish his business. Okay. Your application form listed 2 reserve judgments. Have those been delivered?
Correct, DCG.
All right. Well, thank you very much, Judge Kganyago. I'm going to hand over to my colleagues to ask you their own questions. But first, it's JP Makgoba. Any questions for the candidate, JP?
Thank you, DCJ. Good afternoon, Judge Kganyago.
Good afternoon, JP.
You'll note from the commentaries made by various law bodies that their comments are not so favorable towards you, but I won't go deeper into that, but specifically I want us to deal with the comments which have been made by our Society of Advocates in Limpopo, which is part of the GCB, the General Council of the Bar in the country. They are saying the following, among others, on paragraph 1.9 of their submissions, and I'll refer that verbatim. They say, the Limpopo Society of Advocates has a pupillage program that is still at the developmental phase, taking into account that it was established late in 2015. In our annual pupillage program, we conduct mock trials at High Court, which the Judge President has been a great supporter and participant in providing guidance and leadership. Regrettably, this candidate has stayed away from such initiatives which undeniably contributes to the transformation of the profession through introduction of people from disadvantaged background. The teaching that forms part of the program was conducted at the High Court premises for the first 4 years, and not even once did the candidate lend a helping hand. Further, on paragraph 1.5, they say the following. This observation accords with our observations that the candidate still needs experience to become a leader of the division, in which role he will need to guide other judges. And lastly, on paragraph 1.26, they say, our overall view is that the candidate's elevation to the position of Judge President will not send a good message to the public at large. He is inexperienced and has not exhibited leadership skills nor interest in leadership to warrant elevation. The concern here is that, in brief, that you seem to be aloof in matters of judicial education and uplifting the acting judges as well as practitioners and so on. And this, I must confess, it has been my observation. Now, as a JP, as a Judge President, you have to show interest in the judicial skills or judicial education. So what's your comment on this from the legal profession, really?
JP, you'll remember that from 2018 up to the 31st of March 2022, I was having a long parted matter, that one of Mabilu, which I was doing it during recess. And those workshop was falling in the week in which I'll be doing that long parted trial. I remember at some stage, whilst we were talking, as the JP, you were complaining that that matter is long, is an old case which needs to be finalized. Per recess is either we have 1 week or 4 weeks. For the first, if the recess is for 2 weeks, the first week I will dedicate it to make sure that that trial progresses. Unfortunately, we were hit by COVID for the past two years, and that also contributed in the trial not being completed timeously. And as it was an old case and a long, if in some instances there were some moot trials which were supposed to be, which was held on Saturday, I could not have attended that. As the following Monday, I'll be starting with that part head. I had to refresh. And I can tell you either 2018 or 2019, BLA has arranged a workshop there at court, which was about 3 to 4 days. Because I was available, I have attended that workshop for the whole period. It was not an issue that I was aloof. It was an issue that I was prioritizing that part had to be finalized.
Thank you. One more question. As a leader of your division, my own observation is that with your 5 years period as a judge, you have not been serving in any committee at your division, committees dealing with court administration and or case flow management. And then it is again this background that the one would come to say that you still need more experience as a judge really to progress or to get into a position of leadership, especially not even DJP, but that especially leadership of a judge president.
JP, you'll remember that you have formed committees and you have allocated me and to head the e-commerce committee. This e-commerce committee is the one which drafted the practice directive for the virtual hearings. Those practice directives, when I drafted them, because I believe in teamwork and collegiality, I invited the DJP to be with me as we draft those practice directives. If I did not believe in collegiality and teamwork, I could have drafted those practice directives alone and took the limelight. But because I was doing it for the benefit of the division, I wanted to be with one of the colleagues. And even after the practice directives were signed off by you as the JP, we had a problem of implementation as none of us or our secretaries were trained on that. And with your permission, you allowed me to approach JP Mulambo to assist us with the training. I communicated with JP Mulambo, who allowed my secretary to be in Pretoria for the whole week for training, with the understanding that when he comes back, he will train others. The other problem was the issue that none of the secretaries of the judges were having laptops. I held a meeting with the director of court operation, the court manager, and the chief register to make sure that every secretary is having a laptop for the efficient running of the virtual hearings. And also, as per the policy, they were also entitled to a cell phone. So out of my own work, I've ensured that every clerk of the judge currently is now having a laptop and a cell phone. And I can tell you that after starting with the virtual hearings, I realized that if these virtual hearings are going to be enrolled on a full-time basis, the stenographers' work are going to be rendered redundant, and that is going to lead to retrenchment. I instructed my secretary to invite those stenographers who will be allocated for that week, that she must train them for the future, for in case if the issue of the new technology is rolled out, they will not be retrenched, but they will be able to be placed somewhere, as the division is also been growing and we are going to need the judge's secretary. I can tell you that at the end of the term, I was in the criminal court. My clerk was on sick leave for the whole week. And they wanted to allocate me an acting judge, the secretary who works with the acting judge. But I insisted on working with one of the stenographers whom I've seen that was passionate about learning. And I can tell you that stenographers for that week did wonders. He worked well with me through the trainings which I've told my clerk to train her. I have been a secretary for the Small Claims Commissioner for 15 years. And as a secretary of the Small Claims Court, I was responsible to prepare for the roster for commissioners for the whole year, which is equivalent to preparing the roster for the term for judges. I was identifying new commissioners if others passes away, retires, or due to some other reason are incapacitated, which is equivalent to the JP identifying acting judges. I was responsible, together with the senior magistrate, of coordinating the smooth running of the Small Claims Court, whether the infrastructure was conducive for the Small Claims Court to be run after hours, which is equivalent for the JP, who coordinate all the judicial functions of the magistrate court, which falls within his area of jurisdiction.
Thank you, DCJ. No further questions. Thanks.
Thank you, JP. Advocate Singh.
Thank you, Deputy Chief Justice. Good afternoon, Advocate Kganyago.
Good afternoon.
You have responded briefly to the Judge President's referral to the Limpopo Society of Advocates concern regarding the transformation agenda at point 1.9. And whilst you may have responded to that particular issue raised, may I provide you an opportunity to, in a general sense, tell us what you've done with regard to the transformation agenda and your social responsibility as a judge, notwithstanding what you've just said to the Judge President. Is there anything else you have done to improve the transformation agenda?
This year, during the second term, our DJP referred one of the acting lady judges who are struggling with how to structure a judgment for me to assist her, which I did. And as a JP, you must also have jurisprudential leadership. And as I was assisting that acting judge to structure how to structure a written judgment, I was already imparting my jurisprudential leadership.
Thank you, Deputy Chief Justice. That's all for me.
Thank you, Advocate Singh. Any more questions? Advocate Commissioner Nyambi.
Thank you, DCJ. Afternoon, Judge Kganyago.
Afternoon, Commissioner.
I don't want to have a wrong impression because we are here, so it would be good to ask you, when responding to the Deputy Chief Justice about the composition of that division, you explained to us the tribes of the judges. Why is that important?
For the members of the public to have confidence in court, it must be reflective of the demographics of that province. One race must not dominate the other. Otherwise, it will be seen as a petty court, of which that's not what we want.
The Constitution, when Section 174, dealing with appointment of judicial officers, it's saying the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. Your comment to that, link it with this issue of tribes.
I agree with you 100%, but you must also look at the province where you are. Remember, we don't want the court, the member of the public to lose confidence in the court. Once they lose confidence in the court, they are not going to respect the orders which we grant.
Maybe I'm the one who's losing you. If the member of the public is coming to court, how is he going to know whether I'm Pedi or Tsonga or Swazi or whatever?
The time I was going to the interviews to be appointed as a judge, there were some circular which were circulating that Pedis are being appointed. I don't know where they were emanating from. So they are already aware. So we want to avoid that.
Do you have a sense of understanding of tribalism?
Correct.
Thank you, Judge Kganyago. Thank you, DCJ.
Thank you, Commissioner Nyambi. Prof, and then...
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
There are two cases which I found very interesting when I was reading your catalog. And I'm not really sure which one I should actually deal with. But anyway, let's try this one. It's in criminal law. S versus Mangena. Do you remember it?
S versus
Where you dealt with section 113 of the Criminal Procedure Act.
The one which the magistrate...
Yes, the one with the magistrate, where the magistrate changed the plea and,
yes,
and all those things.
Yes.
That one.
Yeah, I remember it.
Yes. I think your judgment it's a good judgment, and the outcome it's good. I just wanted to pick your brain in relation to this section in particular, because it's not a section that we see much being written on in South Africa. In the magistrate court, yes, it happens a lot, but we don't see it at the high court level. I'm just interested in this case, the magistrate changed the plea before questioning in terms of section 112 of the Criminal Procedure Act.
Yes.
Right? He or she was clarifying the plea when he heard that the accused will be having a
Legal
representation. I'm just curious, in line with section 39(2) of the Constitution, which demands that when interpreting any legislation, one has to bear in mind the spirit and purport and everything. You know that section?
Correct.
Yes. I'm not sure if my question to you is, did you pay enough attention on what the magistrate did in relation to this section? Or were you only looking at the literal meaning of those requirements that are needed for you to be able to change the plea? Because if you look at what the magistrate was doing, as I understand the judgment, It was like, while she was trying to explain, then she heard that there was a potential for legal representation to come in. And my understanding of your judgment is perhaps in the mind of the magistrate was, maybe the accused might have incorrectly pleaded and might plead differently with the benefit of legal representation. And I mean, if you are dismissing the magistrate just like that, did you pay enough? I think you are right, by the way. I'm just asking you from a jurisprudential point of view. Do you think that you paid enough attention to the spirit and purpose? Because the rights that are implicated here is the right to liberty and the right to fair trial.
I did so. The problem is that if we are going to follow it like that, it will be like you are preempting. Remember, the accused was seeking legal representation, wherein he was still going to consult with the attorney or counsel involved, who will advise that accused how to plead. At that stage, the issue of to plead was still immature. Because remember, he said, I want legal representation. He is not pleading. He is not pleading guilty or not guilty. I want legal representation.
It's fine. I'm not going to take it further than that. Okay. On the second case, this one dealt with forfeiture of patrimonial benefits. Anyway, I just want to understand you, because you have written quite enough on family law. I just want to understand your understanding of Section 9 of the Divorce Act. You remember that section?
Yes.
Yes.
The one for forfeiture.
The forfeiture for patrimonial benefits.
Yes.
Yes. I just want to understand, when one looks at that particular provision, can a person who brought an asset in the marriage be made to forfeit that asset that he brought into the marriage? When one looks at those three requirements: duration of the marriage, circumstances that led to the breakdown of the marriage, and substantial misconduct.
What you look, remember, immediately you bring the asset in the marriage, it becomes a joint estate. So if we are going to look at the forfeiture, we're not going to look as to whether I brought A or B. We looked at the circumstances which will give ground for forfeiture.
The Act is clear that you cannot forfeit what you brought into the marriage. You can only forfeit, I mean, the Act is clear. But anyway, I'll leave it there, Deputy Chief Justice.
Thank you, Commissioner. Matolo Dlepo, Commissioner.
Thank you, Deputy Chief Justice. Good afternoon, Judge Kganyago.
Good afternoon, Commissioner.
Okay. You know, you told us about the structural and operational problems of the courts that you in Limpopo, but I haven't heard you. I mean, you are applying for a leadership position. I haven't heard you, maybe I may be wrong, telling this commission how you are going to fix it, or what is your vision regarding that. And the second one also is, you spoke about lack of female judges. And, you know, and now we are applying that. We've got 3 male judges applying here. And how is it going to happen that female judges come in? And how are you going to make sure, if you are appointed, that female judges come to Limpopo?
I've said that I will increase the pool of acting judges, taking into consideration the issue of gender in appointing those female acting judges, in preparing them to be appointed permanently, of which it will not be an overnight thing. And with regards to the structural issues, I said it will be an issue which will need a meeting with the Department of Public Works, the OCJ, and the Department of Justice to have a priority, like the courts in Tondo, where we are only having 3 courts, but the jurisdiction has been increased, and also the workload has increased. That we will just have to have a meeting and have a way forward on how we are going to address that issue, because it is the issue of infrastructure. And on the issue of that, I've identified the one which was the files have been scattered, or maybe there's no space. I said that problem will be resolved by introduction of electronic record filing and electronic record keeping.
Okay, thank you. Deputy Chief.
Commissioner Lucas?
Thank you very much, TCG. Good afternoon, Judge Kganyago.
Good afternoon, Commissioner.
I was covered by Tolo Lepu on the first question. Now, the issue is that when I listened to you, you said that you have like kind of come to an agreement with the DJP that she would not apply for this position. Now, in many instances, when we are appointing women as deputies, we are actually trying to make sure that there is a succession plan within which women will eventually rise to the top in our court system. So what is your view, and why would you agree that only 3 male, black for that matter, apply for this position, and you don't give the DJP also an opportunity? Because I was under the impression when we appointed the JP that day said he's leaving one of these days. He said it in that, when we were busy with that interviews. He's leaving one of these days, so that brings an opportunity for a woman to rise to this position. The opportunity is here now. I mean, what is your view that nothing is happening? Thank you.
Commissioner, I did not say I've agreed. I said when the advert came, I approached her going to tell her that this time she must apply on time, as when she applied for the position of the DJP. She applied very late, and this time I wanted her to do things timeously. And that is when she told me that she's not going to apply, but she did not want to disclose the reason as to why she's not applying at that stage. And she encouraged me to apply, and even told me that she is having confidence in me, and she'll give me my support. Not that we had an agreement.
It sounds very much like an agreement. But generally, what is your view? What would it be if a woman can become the judge president of your division? How would you view it?
I don't have any problem with that, Commissioner. As I've said from the beginning, that when the position of the DJP was advertised, I also had an interest. But since she was also applying, I gave her support and encouraged her to apply. She was even insisting that we both must apply. I said that I'm not going to contest you, since I am having confidence in you, and I don't have any problem in you being the JP of the division.
Thank you, TCG.
Commissioner Makonish?
No, thank you very much, Deputy Chief Justice. Good afternoon, Judge Kganyago.
Good afternoon, Commissioner.
I have 2 quick questions. One of them is, how do you think are the strategic, in fact, who do you think are the strategic stakeholders for the proper administration of justice in that province? How are you going to service them? How will you harness their energies and manage contradictions amongst them?
The strategic will be the NPA, the legal aid, and also the staff component of the court, the master's office, the correctional services, the police, the health, the social services, Yeah, that is what I'm thinking of. And as the JP, you'll also be responsible to chair the PEEC. And when there's any issue which is related to the effective running of the court, it will be dealt with at the PEEC meeting, which will be chaired by the JP.
So the legal profession is not a strategic stakeholder?
No, I've forgotten that the LSSA and the GBC, it is also part of the PEEC.
Okay. The second question, how will you use emotional intelligence to achieve more conducive working environment, thereby improving productivity?
The issue is about the tools of work which which the staff component should have, and also the court in which they are working in. It should be a court, like currently we are having the problem of water, the problem of the aircon not working, which result in some instances the staff having to leave early. Those issues are the issues which need to be addressed. And the issue of the workload, currently we are being overworked. As I've already alluded that we are having a circuit court in Lepalale which is not functioning. I've even given you the figures of how that court is fast growing. So we'll need manpower, which I know that there are some austerity measures in relation to the creation of posts.
The question is, how will you use emotional intelligence?
The emotional intelligence which I will use, Commissioner, is to have workshops with the staff, have meetings with the staff, dealing with the issues which is affecting the court, have a collegiality working relationship with the judges. Because one thing for the judge, the division to progress is for the JP to promote collegiality amongst the judges.
Thank you, Deputy Chief Justice. Thank you, Judge Kganyago.
Thank you, Commissioner. Commissioner Moimang?
Thank you, Deputy Chief Justice. Good afternoon, Judge Kganyago.
Good afternoon, Commissioner.
Just one question from my side, emanating from how you responded to the issue of tribalism in the province. What plans are you going to put in place to educate the public about the danger of the demon of tribalism if you are appointed, which is quite critical because the issue of nation building it's a matter of national importance, and there should be no space, breathing space, allowed for the demon of tribalism to raise its head. Thank you.
Sorry, DCJ, can I just follow up on that issue? I do have another question, but I think I shouldn't miss the opportunity. I think when you answer the question, could you also address my discomfort? When you give us the breakdown of the composition of the court, and you break it down to vendors and shangans and pedis, are you not reinforcing tribalism?
I'm not reinforcing tribalism. Those are the practitioners who are practicing within the division. Within the lower courts, we are mostly they are them. They are the one who are practicing. And if we exclude them, we are making them to feel inferior. Because in that province, whether we like it or not, they are mostly they are mostly in the lower division, and also the practitioners from that division mostly is from those tribes. So without saying that they must exclusively be them, we must also embrace everyone.
No, I mean, I'm sorry, DCJ. You know, I really am struggling to understand your resistance to this. You even say that this is becoming a petty court. I'm just finding it astonishing in a new South African JSC to hear that language. Don't you see anything wrong with that?
I take note of your concern, but what I was raising is what I have observed when I went to the interviews to be appointed as a judge.
Thank you, District.
I'm sorry, I don't understand that question. What observation did you make during your interview?
There was a circular which was circulated the time I went to the interviews to be appointed as a judge, that petty judges are going to be appointed.
So what does that have to do with anything?
I don't hear that, DCJ.
What does that have to do with anything? What is the relevance of that?
It was like we are prioritizing the petty at the exclusion of others.
And where did that document come from?
It was anonymous.
Oh, all right.
Deputy CJ, can I follow that and thereafter ask my question? Now, following on this question, if you are appointed as JP of that province, are you not concerned that there is going to be another anonymous pamphlet saying, here is a petty judge now appointed as our leader?
Unfortunately, currently, they are the one who have been appointed. I'm already in.
Actually, why are you bringing this point and you feel so much strong about it?
No. It's not a question of feeling strong. It's a question of raising what it has already come out in the public. But I take note and I respect the comments by the commissioners.
CJ is fine. If you allow me, can I follow up on my question? Okay, thank you. The position that you are applying for is a leadership position. It's a leadership position. Now, looking at your CV, you worked as an attorney for 26 years, and you ascended the bench 5 years ago. For me, and please fill me in, there is no demonstrable evidence that you were once a leader, you led any institution, you led any people. And if you are appointed to this position, what leadership qualities can you exhibit to demonstrate that you can lead people and make that bench, that division, a very successful division?
Commissioner, in my CV, I've mentioned that I was the chairperson of the Limpopo division, of the Law Council of the Limpopo division, which was therefore the attorneys of the whole of the province for a year. I was the deputy chairperson of the Limpopo Law Council also for a year. I have been in managing the insolvency estate which need management skill for 14 years. I have been a commissioner in the small claims court for 13 years. responsible for the for allocation of a roster for commissioners, which I said is equivalent to allocating a roster for judges for a term. I was identifying new commissioners in the small claims court for those who resigned, those who passes away, which is equivalent to the one which the JP will be doing in identifying acting judges. I was working in collaboration with the senior magistrate in coordinating the smooth running of the small claims court, and also checking the infrastructure, which is equivalent to the JP, who will be coordinating the judicial functions of all the magistrate court, which falls within his division. I was chairperson of the Greater Letaba Valuation Board for 4 years.
Now, when you were asked questions about your vision for the court, you mentioned the fact that you want transformation, you want access to court. I haven't heard you saying anything about modernizing that court and digitizing it to an extent that it is compatible with the current developments. I'm asking this because as part of my oversight function, I visited that court, the same court, High Court in Limpopo, in Polokwane. It was built not more than 10 years ago, but it is cracking, the walls are falling apart, and there were lots of problems about the infrastructure as well as the facade of that court. If you are afforded the opportunity, what is it that you can do? Take into account the issue of modernization and the digitization of the system itself.
Commissioner, I have drafted the practice directive together with the DJP for virtual hearings, which we have implemented it successfully. I've said that I've realized that there are problems in relation to the storage of files getting lost, and the court operating on duplicate files. And that can be resolved through the electronic record keeping system and electronic filing system. And further, that our chief register has already undergone a training on case line, and it will not be a problem in implementing that, and that the chief register is already ready to assist with the implementation of the case line, which will be that of modernizing the court.
Thank you, DCJ.
Commissioner, yes.
Thank you, DCJ. Good afternoon, Judge Kganyago.
Good afternoon, Commissioner.
First, I'm not happy that you don't mention in your leadership track record that you have been in the leadership structures of NADEL for quite a long time, serving a branch in the national structures of NADEL. You don't believe that is important?
Commissioner, it is important. I said I was the chairperson of NADEL Limpopo branch, which is for 13 years. Yeah. And I've served also in the NEC of NADEL for several years, which I've forgotten the number of years.
Yeah. Now, coming back to this question of tribalism, because it's very important to clarify that question. Would it not have been enough for you to draw our attention to Section 174 of the Constitution, because that's the section which makes an obligation to this body when making appointments, when considering issues of transfer. That is the starting and the end line, rather than going to the extent of giving us the details of Shanganis and so, and many people that are there. Because if another judge comes from the Eastern Cape, he must tell us about a lot of other people. In fact, it will go beyond what you're saying. Is it not enough to draw the attention of the commission to that section and give the demographics of that court and how the transformation has progressed? Would you agree with me that that is simply enough and you limit yourself to that?
I take note of what you're saying and I accept it.
Okay. And then the other important question, interest from...
No, before you move to another question, DCJ. Just a follow-up before he moves to another question.
All right.
Okay.
Judge Kganyago, I was asking this guy if we'd interviewed you 5 years ago, and he said yes. And you didn't bring to our attention about this non-existing pamphlet you're talking about. Why didn't you raise it when you came for the interview here, that there is a pamphlet about pedis and all of that?
Commissioner, I did not, I've seen that pamphlet and I could not have raised it because it was anonymous.
But why are you raising it now?
I'm raising it because it is the way the question have come, but I accept that it is how it should be done.
Can you please withdraw that and apologize, because you can't raise issues of tribalism in the manner in which you did here.
I accept that, Commissioner.
Please withdraw and apologize. The public is watching this.
I withdraw and apologize.
Thank you.
Let me quickly wrap up on my question. Now, the picture you give about Limpopo, have you, as a division, considered a rotational system where judges sit in that court, and has that system been adopted in the division?
Yeah, it has been done. Last year, the second term, the first 3 weeks, I was in Thohoyandou. And the judge who was in Thohoyandou was in Polokwane. And this term, the DJP will be this term it will be in Thohoyandou.
Very last question. I get a sense that there's no good relationship between either yourself or your division and the legal profession. In fact, let me limit yourself, reading from the comments that have been made by the Society of Advocates. And then I find that shocking to me with somebody who comes from the background of organizations such as NADEL. Have you not found, or do you not see it beneficial for the court that there should be a healthy relationship between the leadership of the court, of the judicial, and the leadership of the profession, or the profession in general? Thank you.
We depend on the profession in the effective and smooth running of the course, and the healthy relationship should always be there. I don't have any problem with them.
Commissioner Baloyi?
Thank you, DCJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Mine is more wanting to give you the opportunity to clarify and explain something that you said earlier, because, and maybe I'm just too concerned about something that doesn't matter. I think it's capable of being misunderstood. You mentioned earlier on, in answer to a question, that you were asked by the JP at some point to assist an acting judge with the structure of a judgment. And then you went on to talk about providing jurisprudential leadership. Now, I would like to know what you mean by that when you say you provide jurisprudential leadership. And I ask the question coming from this position, that there should never be an impression created that, to anyone who's listening, created that the JP is responsible for leading the direction and the thinking of a division on matters of jurisprudence or law, and two, you're not writing judgments for judges. They're not told and influenced how to write. I think your statement is capable of being misunderstood or understood that way. I would like you to explain what you mean.
Commissioner, it was not the JP, it was the DJP. I was only assisting in how to structure, not dealing with the merits of the matter. The judgment was going to be written by the acting judge, and it will be her judgment, and the outcome I was not involved. It was just to assist for a judgment. You must structure it in this format, yes, only.
Yes, and then you went on to mention about providing jurisprudential leadership. And
yes.
I think that is the more important part that I would like you to explain. What does it mean to provide jurisprudential leadership, and how do you go about doing it? The concept itself, but also what does it mean in your interaction with your fellow judges in the division? We speak of you as the judge president at the time.
As the JP, if you are approached, more especially by acting judges who will still be inexperienced in coming on the issue of substantive law or jurisprudence, you must be able to assist them, not to say that you'll be taking a decision for them. You assist them, like in this case, it was the issue of assisting in the structuring of a judgment, rendering assistance a lending hand, which will be part of training and mentoring.
CJ, I think Commissioner Pillay will take it from there.
May I follow up,
Yes.
CJ? Thank you. Good afternoon, Judge.
Good afternoon, Commissioner.
I was also confused by this notion of jurisprudential leadership, Judge, and having heard your explanation now, may I ask you, the questionnaire asks in paragraph 18, for you to indicate what would you regard as your most significant contribution to the law and the pursuit of justice in South Africa. You recall that question?
You say paragraph?
It's paragraph 18 of your questionnaire.
Yes.
So you see, it's what's your most significant contribution to the law and the pursuit of justice in South Africa? Your answer doesn't talk about anything jurisprudential. Your answer talks about having drafted a practice directive for virtual hearings. And then you go on to explain how you managed the online virtual platforms during the pandemic.
Correct. It is true.
So do we take from that you believe that you haven't given any judgments which are a significant contribution to the law or the pursuit of justice?
I've mentioned the judgment in paragraph. The judgment of Maguru, which I've mentioned that it was of significance.
Can I just deal with that then? You put up three judgments as attachments to your application.
Correct.
Are those the three judgments that you would like us to consider when considering your contribution?
No. There are many judgments which I've written, which are on SAFLI. Here, it was just the judgments that I have attached.
Yes, but I'm interested in how you selected those judgments. Why do you put up those three judgments?
This judgment, I've just put them because I found them to be interesting, like the one for Lionel Nutley. They are not cases which comes regularly to the courts.
Right. The difficulty I have, Judge Kganyago, is that the Notley judgment, the first one is the judgment that you sit as part of a full court.
Yes.
So it doesn't really give us an insight into your writing. The other two that you put up, the one is a matter involving what seems to be a straightforward divorce and custody case. Do you agree with that?
I agree.
And then the last one seems to be a straightforward insolvency matter. And what you do is you mark that judgment not reportable. So there's nothing of significance that flows from that judgment either.
It was not, this one on insolvency, it was not as straightforward. Because if you read the facts here, the attorney who was involved in this matter, who was also a member of the CC, was trying to play hide and seek. So it was not as straightforward.
But you didn't consider it necessary to mark it reportable or of interest to other judges?
Yes.
So the difficulty I have, and I really want to put this to you, Judge Kganyago, is that your application doesn't seem to showcase any significant contribution made by you to the development of the law or to jurisprudence. And I really want to give you an opportunity to deal with that.
In paragraph 16.1 and 16.2, I've listed the cases, the one of Maguru which has been reported.
And those are the cases that you'd like us to consider?
And also the one which is unreported, which was referred in the Commentary Act.
Right. Thank you, Judge.
Jay, can I follow up on Commissioner Pilay's point? Because it's actually on this point that I wanted to comment, but I couldn't miss the chance to reflect on the tribalism point, which has now been withdrawn thanks to the intervention of Commissioner Malema. Now, the Notley case, which you highlight as one of your significant achievements, correct?
Correct.
Now, I've read that judgment, your judgment. That judgment is about the payment to an employee who was reinstated by a labor court judgment and an arbitration award, but the employer played hide and seek and refused to reinstate them. Correct?
Correct.
Now, there's no new principle in that judgment.
I agree.
So, if there is no new principle, what exactly is the significance of this judgment? Because it applies the Ick versus Parsons construct on interpretation of orders. It then applies the Constitutional Court judgment on what is the meaning of reinstatement. But both of those are benign, if not banal, common garden legal concepts.
So when I was reading, when I was writing this judgment, it was the issue that this type of cases rarely come to the High Court.
No, but this type of case specifically regularly comes to the High Court.
I take note of that.
So even the one then that you said is your best contribution is actually quite benign. There's nothing here that is significant. But I want to ask you something different with this judgment, which is you cite the Ick versus Parson interpretation to court orders. And then in the following paragraph, you refer to end-domain, which is interpretation of contracts and other documents. Do you think there's any distinction between interpreting a court order and interpreting an ordinary document, a contract between two parties, or is there no difference? That's the same thing?
There are differences.
I see. What are the differences?
Remember, the court order is an order which has been made by the court, and the contract is the document which has been signed by the parties and has not yet been made an order of court.
No, that doesn't explain what is the difference that a judge brings into how to interpret either document. And your judgment actually treats them as one and the same.
It was about the intention of the parties. What do the parties intended to do?
Yes, and then the other is the intention of the judge, what he intended to do.
No. It is an order which has been made out of the intention of the parties.
I'm not sure I understand. I'm sorry, I'll have to just take this slowly. You say there is a difference in how to approach the interpretation of a contract as opposed to a court order, correct?
Correct.
What is that difference?
The court has already made an order.
Yes?
Which will remain valid unless it has been set aside.
Yes?
The contract, the parties have signed with their intention as to what they want to resolve.
Yes.
For them to resolve from that, they have to approach the court.
Yes. What is the difference in interpretation? Let's go back. You know, the basics of interpretation are you read the text, you interpret it in the light of the context of the other pieces in the same text, and you try and find the purpose. Those are the 3 steps. What is the difference if you are looking at those 3 steps to an order versus looking to a contract?
The order will remain the order of the court, and the contract will be the intention of the parties, or what the parties have intended.
Yes, that is just descriptive, that these are 2 different documents. It tells me nothing about the approach to interpretation. Anyway, thank you, TCJ.
You want to respond to the last comment? I don't think it was a question. Judge Kganyago,
DCJ?
do you still want to respond to what Commissioner Mgaitobi said?
I take note of what the commissioner said.
All right, thank you. Did you get your chance? Yeah, it's your turn.
No, thank you very much, DCJ. Good afternoon, Judge Kganyago.
Good afternoon, Commissioner.
Thank you very much. My attention is drawn to one of the cases you penned, is Shai versus S. You remember that judgment? Shai versus S versus the state. It's in 2020. Unless it was not penned by you, I'm prepared to drop it. Yeah, it was penned by yourself.
Yeah, if I can just have a...
The facts?
Yes,
okay.
Because we are writing many judgments. I don't want to confuse them.
It's fine. And in this case, it's a rape case. In this case, the state proved that the appellant had the necessary intention to rape the complainant. And both yourself on appeal and the lower court accepted the complainant's evidence that she was raped by more than one person. But for these reasons, that the complainant was raped by more than one person, the lower court sentenced the accused to life imprisonment in terms of Section 51, subsection 1 of the Criminal Procedure Act. But on appeal, you reduced the sentence to 10 years, that's a minimum sentence, and because that's what you said, because the appellant was the only person before the court, and the accomplice was not had not been arrested by then. the only basis for reducing the sentence from life imprisonment to 10 years, even after I've accepted the appellant's, the complainant's evidence that there were more than one person involved in the rape, but you still reduce it to 10 years on the basis that the accomplice had not been arrested and brought before the court. And where I'm not clear is, if after you've accepted that, why you still reduced the sentence from life imprisonment to 10 years? In other words, moving it from Part A under Schedule 2 to Part 3 under Schedule 2. Thanks.
It was on the basis of the decision of Matlasi versus the state, where it has been clearly stated that where the accomplice is not before court, the life sentence will not be appropriate. Hence, the sentence was reduced.
So your argument, your position, Judge, is that even after you have accepted the complainant's evidence that there was more than one person involved, you would still reduce the sentence from, it's proper to reduce the sentence from life imprisonment to 10 years on the basis that the accomplice has not been arrested. Is that your position?
It is on the issue of following the precedent system, which the Supreme Court, this judgment which I'm referring, is from the Supreme Court of Appeal, and as the High Court, we are bound to follow it.
Interesting judgment, thanks.
Commissioner Bernard.
Thanks, DCJ.
Thank you, Commissioner Globo. Commissioner Bernard, do you have questions for Judge Kganyago?
No, DCJ, I'm fine. I'm covered, thank you.
You are excused, Judge Kganyago. Thank
Thank
you so much.
Thank you, DCJ.